5 seconds to go. Start. According to the petitioner, only redacted opinion was supplied to the petitioner. In the circumstances, petitioner sought the complete opinion formed under Rule 3 of the SEBI Adjudication Rules 1995 by the adjudicating authority. It is argued that show cause notice relies heavily on the probe conducted by an independent agency called MSA Probe Consulting. The said MSA Probe Consulting submitted a report upon completion of investigation along with all supporting documents. The said report, along with its enclosures, was made Annexure 1 to the show cause notice. Mr. Luthra argued that while deciding whether or not to issue show cause notice, SEBI relied upon the MSA probe report and its enclosures but refused to supply the same once the petitioner entered appearance on the contention that it would not rely on the said documents. It is contended that respondent SEBI withheld the following documents. Mr. Luthra submitted that while respondent SEBI has taken a stand that documents are confidential without giving reasons, the adjudicating authority had on 26 August 2021 taken a stand that documents would not be relied upon. He stated that the documents at 1, 3rd and 4th mentioned above were stated to be confidential documents. Mr. Luthra submitted that the documents relied upon by the respondent SEBI, the show cause notice, could not be denied to the petitioner. In Natwar Singh vs. Directorate of Enforcement and others, this court held the concept of fairness may require the adjudicating authority to furnish copies of those documents upon which reliance has been placed by him to issue show cause notice, requiring the noticee to explain as to why an inquiry under Section 16 of the Act should not be initiated. To this extent, the principles of natural justice and concept of fairness are required to be read into Rule 4.1 of the rules. Fair procedure and the principles of natural justice are inbuilt into the rules. A noticee is always entitled to satisfy the adjudicating authority that those very documents upon which reliance has been placed do not make out even a prima facie case requiring any further inquiry. In such view of the matter, we hold that all such documents relied on by the authority are required to be furnished to the noticee, enabling him to show a proper cause as to why an inquiry should not be held against him, though the rules do not provide for the same. Such a fair reading of the provision would not amount to supplanting the procedure laid down and would in no manner frustrate the apparent purpose of the statute. In this regard, the learned senior counsel for the appellant pressed into service the doctrine of duty of adequate disclosure, which according to him is an essential part of the principles of natural justice and doctrine of fairness. A bare reading of the provisions of the Act and the rules do not support the plea taken by the appellants in this regard. Even the principles of natural justice do not require supply of documents upon which no reliance has been placed by the authority to set the law into motion. Stop.